Okay, so we're just right now going to spend a little bit of time in our website because there's a lot of information on the website, and we got it blown up so you can actually read certain things and stuff. But let me take you first to the top part of our website. You'll see labor law right there, the first item on top on the row. And labor law, think of that as the labor commissioner's office. So when we hit labor law, you get this ribbon that comes down. So let me pull off. Labor law, I get the ribbon. So we have wages, offices, BOFE. BOFE is the Bureau of Field Enforcement. Minors, again, the labor commissioner deals with the enforcement of child labor laws. Our policy, this is a really great little resource. If you want to know about general wage and hour law, we have the Division of Labor Standards Enforcement's Interpretations and Policies Manual, which is a fantastic manual that we've had, that we trained our deputies for the last 16 years that I've been around with the Labor Commissioner's Office. Our various databases, opinion letters. So you might get general questions. What's the difference between compensable travel time versus ordinary commute? That's another question that can, especially in public works. Ken spoke a little bit about that type of an issue where you may have contractors that have their own vehicles, and they say to the workers, why don't you come in, get a ride. We'll take you right out to that public works site. And it may be compensable if the night before they forgot to load up the vehicles, and so they start loading up those flatbeds or those trucks with materials and supplies. Guess what happened? Their day started. So we have that Meroilian versus Royal Packing Company decision, which is a California Supreme Court case that deals with compensable time of hours worked. One of my cases, he referenced the current asphalt case, which is a newer decision. But if you go back to 2001, 2002, I had a case involving a project up at the North Coast, up in Arcata, that dealt with compensable travel time for a wastewater treatment plant that required workers to either get rides or walk up a 3/4 of a mile hill to where the project was located, because the contractor entered into an agreement with the awarding body and all the homeowners. They didn't want that much traffic going up and down a private road. And hence, Kirkwood Bly was forced to pay hundreds of thousands of dollars in back compensable wages. Certain things, again, resources, opinions. Retaliation, those are going to talk about our 45 different types of retaliatory types of acts. Again, training, postings, all of the postings that are required by employers in the state of California you're going to find there. And all of our different sites that deal with public works will also lead us back to that public works, that wrench page. Again, going just up the road or down the row here, Cal OSHA, workers' comp, self-insurance, apprenticeship, that's the DAS page. Director's office, that's Ken Lau and the folks at research, plus some other programs that we have at the director's office, and our various boards that we have within the department. So I want to spend some time, since we're dealing with the Public Works rail, to go ahead and click on our Public Works. And it's thinking. Did you bring in some of our state computers? No, that's what I was wondering. Yeah. Actually, my iPhone is a hotspot. It might be faster. But anyway, so as you can see, we've done a lot of work with our web page. We have a tab for both contractors and for awarding bodies. Since we don't really have any contractors in the room today, should we focus on the awarding body section? And computer's thinking. But the awarding bodies, this is going to tell you how to register under our PWC 100 to tell us about your projects. It also talks about responsibilities. So this is that Labor Code Section 1726 requirements and some other Labor Code requirements under the Public Works statutes that all projects now must be reported to DIR within 5 days of project award. Prevailing wage rates, where to find them, that goes into our Office of Policy, Research, and Legislation. Notify your potential contractors that they have to be registered with the Labor Commissioner's Office or with DIR, and the project is subject to enforcement. So that's that provision 1771.1A that we talked about earlier today. Require proof of public works contractor registration before accepting a bid or awarding a contract. And this is just a cautionary tale. We say that if you don't do that and you award a contract to a non-registered or unregistered contractor, you have now opened yourself to a lawsuit, because your second lowest bidder who was registered should have gotten that project because you just awarded to a non-responsible bidder. Make sense? Okay. You have to post or require contractors to post job site notices. We're saying basically that this project's under the enforcement of the Department of Industrial Relations and the Labor Commissioner's Office. Ensure that public works contractors pay prevailing wages and are in compliance with public works laws, and report any suspected public works violations with the Labor Commissioner's Office. So this is just basically a synopsis of Labor Code Section 1726, taking cognizance of violations. And then we gave you the tools to search to determine whether or not your public works project has been registered, and to find submitted payroll records to see whether or not contractors are registered in our public works contractor registration databases, as well as you can see under resources, public works coverage determinations. I'm not sure, is this a public works? So if you click on the public works coverage determinations, this is a great tool. This is good for not just awarding bodies, but anyone interested. How has the Department of Industrial Relations looked at specific cases to determine whether or not public works is required? And as Ken talked about earlier, we have all of our coverage determinations going back to 2002 by topic and by statute. Getting a little slow, but it's kind of a nice little tool, because from time to time we may get specific questions regarding, we have a lease type of a procurement delivery system. How does the Labor Commissioner or the department view that as a public works? And as you can see, it's alphabetized, and it has a drop-down menu of various types of issues. So I know Ron talked a little bit earlier today, asked about charter cities. Well, we have that. Those determinations that affect charter cities. You can kind of see all sorts of topics, right? Conduit bonds, construction loans, de minimis. So I learned something new today. I thought de minimis was anything that was 2% or less was de minimis of the total project cost versus the public fund. And I learned today it's 1.75%, right? So is determined to be de minimis. So those are the types of things that will allow us to look at certain things. Gift of land is a topic. So just because I want to see what gift of land is, we actually have, look at there. Wow, what is that? Gift of land, search. I didn't hit search. Something's not right here. We didn't have 10 determinations of gift of land just in this last year. So let the computer think and spit out the answer. I imagine that we have about 1 or 2. Oh, looky there. Gift of land. So we have a little bit more than that, right? So and so again, why would we? Is this forward? Search forward. Okay, we'll have to do that up here. I don't think there's anything that is forward. Okay, I'm going to go up on top. There's nothing for forward under our. That's a specific body, so you won't be able to search by a particular body, but based off a topic more than anything. But I typed in forward just under the general search, and anything that's on our webpage that's involved forward should pop up. It's searching. It's loading. It says so. What are you loading? Search results. Loading. What did you get? Yeah, so there's results. It's still thinking, I think. That's why. Okay, Sherry got results. All right, let's try that again. Refresh. Yeah. No worries. There is actually search results. For some reason, it's not coming up here, but we have a DLSA wage claim office locator for FORA award. That's just basically what city are you in and which office would you go to. So it's going to refer folks into our Salinas office for anything here in Monterey County. And then we had some results that involved our Cal OSHA side of the house with pressure valve registration database. And IWC. He grazed Fort Ord for a number of years while he was in active military base. So there's not anything that's specific in the public works realm that's dealing with Fort Ord in particular, which doesn't surprise me because we don't have a, it's really based off a topic. So it'd be more of issues of public funds more than anything. So let's go back to, public works real quick. As you can see, though, you can search by topics. So if you had a question, what is public funds? You know, various types of procurement delivery systems, do they trigger public works or not, or what have you? You know what? I don't know if it's still thinking. Real quick, I want to show you where the newsline information is that's coming up, and of course our public works manual, where to find that. So if we're going back over here, oh, we're already there. You have the resources side of the buttons here. We have apprenticeship requirements, certified payroll reporting. So if you want to know about certified payroll reports, you can look there. Enforcement of public works law, that's going to be what our office does with the labor commissioner's office, how to file a public works complaint, labor compliance programs, and how the department oversees those agencies that have a labor compliance program and the prevailing wage requirements. We go into the, let's go in real quick to the enforcement of public works. And it's thinking. And one thing that we should have is some resources. So we have the Public Works Enforcement Manual. How many folks have reviewed that or used that from time to time? Handful, right? Great tool. As you can see here, 49 years in jail and over 635,000 subs for short-changing employees. So you can, what's in the news? Those Hilton Hotel cases I talked about, over 8 million in unpaid wages. So you can learn more about what happened there. But on the right-hand side, let's see what we got. Maybe let's go back here. What must contractors do to comply with the law? Keep and submit certified pay records, comply with apprenticeship standards, pay prevailing wage. Of course, there's a little bit more than that too. They must be properly registered, which is on their homepage, and to definitely abide by all provisions of the labor code. Here we go. So here's your resources on the bottom here. As you can see, we have the California Labor Code, but if you go down to our Public Works Manual, this is a very useful page. And as you can see, we just updated it in August of 2016. And a lot of times what I'll do is I'll just hit Control F and look for key terms. So does anyone want to give me a topic that, you know, as far as questions regarding what might be in our manual? There's lots of them, right? I can cheat if I'm a contractor and I'm an open shop, non-union contractor. However, I pay into a pension plan for my workers. And so I want to know, I spend $1,000 per month contributing to my workers' health and or their pension plan or their health and welfare plan or what have you. How can I take credit? So employer contributions, type in contributions. Right, hit search, and every word where the term contributions is going to take you to that part of the Public Works Manual. So the prevailing wage laws permit contractors employing workers on public works to pay a certain portion of the total hourly rate reflected in the applicable prevailing wage determination published by the director, either in cash to workers or as contributions to specific plans or entities as employer payments. And then it gives you the law, right? It gives you the Labor Code statute, it gives you the Title 8 statute, and then you can hit search, or you can hit the next one. Let's see, contributions. There's 27 times that contributions are in here, and you can keep clicking. And basically it'll give you, it's a quick way to do some, quick study or what have you. And of course, the answer is they're allowed to do annualization. Everyone heard of that term? So that basically the Labor Commissioner has adopted what the U.S. Department of Labor allows in their Davis-Bacon projects. And so just because I pay into a pension plan or health and welfare, you can't take all that money and use that as your payment for that particular project. Does that make sense? So you have to annualize. You have to spread out that benefit for all work that worker is doing. You can't front load. There's a lot of manipulation that can be done if you allowed for them to load it up into that public works project. And what we're saying is, okay, we recognize that you're paying a contribution to your employees, and yes, you're entitled to a credit. But what we'll do is we'll use for full-time employees, 52 weeks a year. Multiply that by 40 hours in a work week, and you get 2,080 hours. No questions asked. We'll allow you to take an hourly credit off of that 2,080 hours. So if I spent $12,000 a year on a pension for one of my employees, I can claim a credit, divide that by 2,080 against their prevailing wage obligations, as long as the total value of the employer contributions do not exceed what's required in the base rate. Make sense? Yeah, so if base rate, I'm a carpenter, I have a base rate of $42 an hour as my base rate, I have another $9 that go to health and welfare, I have another $5 go in pension or whatever it is, and I have a total hourly rate of $60 an hour. The employer, non-union employer, has to pay $60 an hour, but at no time can they pay less than the $42 an hour in base rate. But they can take a credit up to $18 in various employer credits. Okay? Okay, so you can just get a flavor of the Public Works Manual. Let me back out real quick, back to Public Works. And as you can see, this computer is as fast as my computer at the office. What's new? So we talked earlier today, you can get Public Works email updates also on the Public Works page right here on Stay Up to Date. But the big thing that just popped up was DIR appeals U.S. District Court order blocking Labor Commissioner enforcement of AB 219 prevailing wage requirements for ready-mix concrete suppliers. And this is what our news lines look like. And as you can see, I had a lot of groups calling me last week when I was out saying, how is DIR going to handle this federal lawsuit and this injunction? And so the DIR has appealed the preliminary injunction ordered by U.S. District Court. They're in the Central District. The order temporarily prohibits DIR and the Labor Commissioner from enforcing new prevailing wage requirements in the ready-mix. And this is not a final decision by the court, so we want to make sure that we emphasize that. In its appeal, DIR will seek a stay of the preliminary injunction. The injunction is stayed and DIR is successful on appeal. The department intends, this is the critical part, to enforce all prevailing wage requirements from AB 219's effective date of July 1st, 2016. So it's basically advisory notice to the public and to public owners is that that this is not something we're gonna fight it. Now ultimately we could lose, and ultimately we may be stayed from doing enforcement, but it's letting the public know that where the department stands on this particular lawsuit. Any questions on that? Okay. So lots of good information. That's what I'm getting at here. Anybody want to, anything in particular you want me to cover? Speak up. This is your time. Direct me. Yeah. Maintenance. Yeah. So there's lots of ways. Yeah, you have to be. So here's what we tell public owners. If you know that you can reasonably anticipate that you're going to spend more than $1,000 with any particular vendor / contractor, treat it as a public works. Because as soon as you go to $1,000 and 1 penny for a particular vendor that you keep utilizing, that vendor now has to pay prevailing wage and is subject to public works laws. Even though it's randomly different location, because we're not concerned with what the location is, we're concerned that it's much easier to try to use that as a scheme not to pay prevailing wage and require that the public works laws apply. Does that make sense? So what we say is, every city, county, school district, they may be on a fiscal year. It varies by the governmental entity. But you can look back at past practice, past history. Now there's times when you can reasonably anticipate that this is a one-time project. It's under $1,000. You don't treat it as a public works. You don't intend to use that contractor going forward. Things happen, but as soon as that contractor comes back and another purchase order is provided, and now they're providing the same service, you really have a public works contractor at that point. Okay. Maintenance is just one definition of public work, and it's unlike the other construction, alteration, demolition, installation, repair. It's found in 1771 that further defines what maintenance. Yeah, so if you have the force accounts is what they're called in the public contracts code. And each public entity has a certain dollar threshold, and you can utilize, sometimes it's 10,000, sometimes it's 50,000, sometimes it's more. It depends on the size scope of the public entity. Obviously if you have it is in the statute, but it's statutory by types of agencies. So school districts will be different necessarily than cities. Cities will be different than counties. So it's all in the statute, it's all in the code, but there's different thresholds.
Just like you said earlier, you didn't bring anyone from
Yeah.
with you. There's other things you can get into the California construction cost procedures. You have various thresholds there.
Cupcake.
Get in,
It does. So they absolutely, just for school districts, they can enter into CUPCA, which I call cupcake because I can remember it that way. It's sweet. Or they can have the traditional, which has a different dollar threshold. But it's all part of, I can't exceed it, right? Once I get to that certain dollar threshold, I have to not use my own employees. I have to then put out the competitive bidding.
Right, and there's just another layer of complication to that. In the public contracts code, not only is it based on entity, if you're a state agency or a local entity or agency, if you receive dollars from a state agency or a federal agency, it might kick you into a different contracting type of arena than you would ordinarily be as a local agency.
So yeah, there's definitely different levels of complexity. So not just public works law is hard, but public contracting code is hard as well. Okay, so should we look at, let's take a look at, since we have awarding bodies, let's take a look at how to search public works projects real quick. Now, in smaller, more rural areas, it's probably easier to do searches than if you're having to try to find a specific project at LA Unified School District, right? Because they award, thousands of projects each year, and so, so to do that, just go into our find a registered public works project under the search function, and we definitely, we're looking at trying to do some enhancements with the PWC 100. One in particular that we're trying to do is right now, you can't search by date criteria, which doesn't make any sense to me. Uh-oh. So the computer says it doesn't work past 3:30. But we say, I will pay you overtime. Nope. Server DNS address could not be found. Hopefully that's here and not the statewide issue, or our phones are going to be blowing up. Can you do it on your computer? Okay.
You can find a registration number though on a project from there by county or so.
That's right. And one of the things that we look at, and it looks like that's down, checking the proxy firewall DNS configuration. So what we're, yeah, you can search projects. If you're looking for a project, if you're dealing with an agency that has over 500 hits, it's going to say refine your search. You can look at, you may want to cut it down by looking at projects that were awarded in the last 90 or 180 days, and that can also be able to narrow your searches and stuff. But it is, the search function is not as good as it should be as of yet, and that's something we're going to work on trying to fix. It's not working on yours either, Miss Jerry? Nope. Okay, so hopefully this is a local issue and not a statewide issue. Or, yeah. Well, let's look at the barred contractors. Oh, well, this one's not a big search engine at all because our database, we don't have a database for debarments, we have a spreadsheet. So that's the good news. So you can kind of take a look at what's been happening recently. So we just have our latest debarments for a contractor, Del Norte Construction, and Trinidad Manuel Canales, an individual. You notice that we go after both the company and the perpetrating individual. And I told you the 4 reasons why debarments occur, right? Intent to defraud, multiple willful, serious violations of the apprenticeship law, and failure to provide certified pay records within 30 days. Some of the criminal side, I didn't talk about this, but People versus Wang, it's a published decision in criminal court, talks about different schemes. In this particular case, Mr. Wang perpetrated in this particular case that basically was a felony under wage theft. Labor Code Section 1778. The first scheme was the traditional scheme. It was, I give my employee a payroll check, and we go down to my brother's convenience store. We cash the check for a fee, and then we demand a portion of that money back from the worker. Then the public agency or the labor commissioner gets a review. We say we want to check to see if prevailing wages are being paid. We get a copy of the check showing full payment. That's a felony in the state of California. Second way, same contractor, the court deemed to be a felony, taking a coercion of a person's payroll there. The second way was they had a job foreman on the project, and they had the worker sign the back of the check. Workers never saw those payroll checks. The checks all get deposited into the employer's account, and of course the workers get paid their $15 an hour, not their prevailing wages. Again, felony, taking a portion of a worker's wages. Third way, another group of individuals, they said if you get interviewed by job inspector or somebody from the labor commissioner's office, you tell them that you make $42.50 an hour. Everyone knew that they were making between $15 and $20 an hour. That too is a felony to lie about, making your workers lie about what they're being paid.
So in all those cases, you have a body?
Yeah, we have victims. The fourth way, which is the most egregious way, well, they're all bad, but let's talk about what happened in the fourth scenario. I paid one worker perfectly, but then I told that worker to pay 5 other individuals. So guess what happens to this worker at the end of the year? They get this. Yep, they get in this beautiful W-2, and then on this W-2 it says, "Oh, by the way, now you have a $20,000 tax liability." Guess what this worker did? Worker went back to the employer, said, "Hey, I can't afford $20,000. What does the employer do? "Hey, I'm a good-hearted person. I'll loan you that $20,000 with a great interest rate." So yeah, those are the types of things that we do see out in the public works arena, and this is the ones we want to make sure we try to put a stop to lying, stealing, and cheating, because this is hurting.
Or paying all the wages and benefits, but unfortunately the pension fund's fraudulent because it's his wife's vacation fund or something.
Yeah.
Hey, Eric, so I'm looking at this, and about halfway down,
Yep.
there is a company called Ramos Painting, and it's got a date. It says 11/13/14 through 11/2/15. I'm assuming that means they're no longer debarred.
Yep, that's true.
So is this a current debarment list?
This is the most current list that we've had just over the last, well, how far back do we go back?
So it looks like this was updated in October of 2016.
We do like to keep them up there for. See, there we go. See, this.
Oh.
Is,
Well-
so what we do is also we want to let the public owner know that there's been a history of bad behavior as
Gotcha.
well, and so we don't always take it off, even though, as you can see, some of these have expired back in 2012.
Right. So if I were a public awarding entity and somebody showed up on this list and I said, "Oh, it's 2016.
Yep.
And I now have a lowest responsible bidder because they are now able to be registered again, and it's 1AMD Construction Inc."
Yep.
This would not preclude me from awarding that contract. Is that
That's
right?
correct. So that's going to be asking more questions, right? That's your tip to say, okay, we know you've had history with this. Now, a lot of times what happens is they reinvent themselves, and so you're not going to know it's one AMD Construction Inc. because now there are 2 AMD Construction Inc. Right? Or, instead of having me as Alberto Mordauki, I might now have, or Morella, I might be looking with my brother or my cousin with a different name, even though I might be pulling the strings behind the scenes. So those are the more challenging types of things. But it gives you an idea, at least, of what the Labor Commissioner's Office has done with debarments. We have one debarment which was unprecedented. It was a series of debarments year after year, because the statute gives us an ability to go up to 3 years to debar a contractor. But if you look at this particular contractor, let me see if we got it. Yeah, they're barred for several decades. And what we did was a concurrent debarment. So here we go. How do you like that? I've never seen it. So they're debarred through the year 2047. Yeah, well, we'll see. I don't know. I mean, obviously, I don't know if Fast Demolition's going to file a lawsuit for us to say that, wait a minute, we've gone beyond our authority. But we've taken a legal position that we can do this. And so we've debarred, very over... Yeah. And some of the nuances of enforcement is that not all district attorneys' offices are wanting to take our wage theft cases. So in areas where we don't have those cooperation from those district attorneys' offices, we have other, administrative ways to try to address that issue as well. And we have several cases right now that we're just waiting for decisions to be, completed. So it's kind of interesting. We do, again, it's really some of some of the reasons why we debar contractors is we have contractors that have done something really bad, and they say, listen, you assessed over $1 million in penalties. We just can't afford it. We want to continue to operate. We'll enter into a stipulated debarment, which is great and dandy, and sometimes we go with it. Yeah, for 3 years. And so what happens is it allows them to work on private and commercial, but gets them out of the public works arena. Now, in cases where we go through a full adjudication, it gets heard, we have a record, it's under penalty of perjury, everything is a sworn testimony and what have you. When our decisions are upheld, the contractor state license board, if it's a contractor that's required to be licensed, will take that and take action against their license. So what it does, it effectively gets that contractor not only out of the public works arena, but also the private side of the house with residential and commercial. So, and we have our partners at Contractor State License Board that scour everything in our contractor registration, as well as these debarments. And so we work closely with them as well. Any questions on that? All right, look at, we've got 3:45. Want to beat? Yes. How do we find the master labor agreements? So, not necessarily, but what happens is on this website, we talked a little bit. How does the department, what is the prevailing wage rate? Let's go in there real quick though. Office of Policy Research and Legislation, which Ken was speaking earlier. He's the attorney for that, for the research unit. And the director will stamp, that we're endorsing certain provisions within the collective bargaining agreements for various crafts. Now, we're not stamping that the whole agreement has been blessed. Only certain aspects of the agreement. Wage rates, including shift differential, is one of them. Scope of work, who can do the type of work for workers. So we'll adopt that. Travel and subsistence, because that's a component of the prevailing wage rate. And holiday, so certain crafts, it will say that if you work on a holiday, and they'll define what the holiday is, you have to be paid a premium rate, usually at a time and a half rate. We don't go any further than that. In some cases, as Ken was saying, we might have new agreements that come in a particular labor management group will say, hey, we're going to do some additional stuff. One that comes to mind in the laborers agreement, they said that we can do the third rail on a train like BART or what have you. And what did the Office of Policy Research and Legislation do? No, the electricians already do this work, so they got whited out. So in order to determine, the wage, what the proper wage determination is and the proper scope of work for the proper master agreement that's on file with the director's office, you're going to need to know the first advertised bid date, or if it didn't go out to bid, the first legal document. A lot of times it's the contract date. Once you have that, we can go in to the director's page here and look at prevailing wage determinations. Let's take a look at one real quick, if it works.
While we're waiting for this computer to go up, if you type in that upper right hand box, the search icon, and you type in master labor agreement, it will populate a list of the labor agreements that are there. Now, it won't be tied necessarily to the prevailing wage determination, which is the other avenue by which you can get to it, but you can get to a list. And for example, there's a 2014 laborer master agreement for Monterey County along with some other counties, and it's the first item right up.
Yep. So as you can see, this is the general list, bullet points. What's going to be reflected always is going to be the most current prevailing wage determination. So the 2016-2 is up there. What date was it issued? Anyone? Yep, August 22nd, 2016. But if I had a project that was first advertised for bid back in 2014, just let's say January, we would know that the 2014-1 wage determination is the effective determination. How would I go and look at that determination? Because I don't want to go into the 2016-2 for that. Superseded, exactly right. So you go into the superseded prevailing wage determinations, you click on that, and it will give you all of our wage determinations going back several years. When I say it goes back to 2001 or 2002. Now, back in the day, when Shirley and I were doing investigations, we didn't have this thing called the internet. We had these binders of wage determinations that had to be mailed out. And in some years, back in the 90s, it didn't come out twice, but it came out 3 times. So that was the last time it came out 3 times. I want to say it was 1999. But anyways, as you can see, we get the list of the superseded prevailing wage determinations. And for my example, as you can see how far back it goes. It goes back to I think it goes back prior to 2000s. Please note that the above wage determinants are superseded for projects advertised on or after September 1st. Okay, so I guess they started indexing them. Used to go back to 2001. So 2014-1, we can go ahead and look at the effective wage determination. And so I'm just going to use the laborers as an example because I used them prior with this third rail. I know this because I got an upset business agent saying, we have a third rail in our agreement. Why isn't DIR recognizing it? Because there was already a craft that was claiming the work was the answer. So if you go into Northern California, here's the thing too. I mean, obviously, you know, we've been dealing with public works. Those of us who know where to find certain crafts and classifications, it's easier. If you're doing this for the first time, there's a lot. It's confusing where to go. And so one thing that we're trying to work with is, I don't know if anyone has to deal with other states, but the state of Washington has a really nice little way to look at wage determinations. And what they do is type in where the project's located, and it gives you all of the applicable crafts for that location. We want to do something similar for California. Now, we're a lot bigger than the state of Washington. I mean, by ourselves, we're currently, the last I heard, we're the 6th largest economy now. Yeah, Shirley. Yes. So if you're using relations, because sometimes you have to deal with both, right? Stricter of the 2 laws if you have federal funding on your project. And so, but it's kind of nice that certain, you know, relations and others have already pre-populated what the wage rates are, which makes a big difference. So as you can see, the various crafts, I'm just using labor. It says, as you can see, here's the increase. So if you want to know what's the changes for an effective wage determination of 2014-1, my example is I first advertised January of 2014. And for the laborer's craft, the computer says, I am thinking. But generally what you're going to see is 1 or 2 or sometimes 3 different years of predetermined changes. And in this particular cases, of course, we have different, again, a little bit more nuance for projects that were advertised for bids on or after March 4th versus, and then for projects advertised for bids on or after April 11th. So what does that tell me? There was an interim, there was probably some type of special notice. And as of that special notice, there was some changes. But as you can see, you can look at the various agreements as it relates to holidays, scope, travel, and shift. Because I'm really interested in scope, I go into the scope of work. So as you can see, you get a cover letter from DIR. And do we see Monterey County there? Yes, we do. So you know that you are you're not Central, you're Northern California, according to the laborers agreement here. And of course, a little memorandum of understanding. And as you go into the scope of work, as you can see, this agreement was entered into between the years of 2012 and 2015. So all of this, and you see the receive date. That's what I want to see. I don't want to see an agreement without that stamp. So if I'm an investigator for the Labor Commissioner's Office, I'm looking at all of this. And look at all of that whited out. Oh my goodness, what happened? So if I looked at the Labor's Master's Agreements, I'm going to see what's behind door number 1 there. Most likely that's the third rail. So you can kind of see what happens. So this is what we can enforce. We can't enforce the CBA. We can enforce what the director has adopted in a form of a CBA, if that makes sense. Okay. Now there's sometimes we have this overlapping crafts, and I don't know how well they did it 5, 10, 15 years ago, but we had this decision, Henson v. Overa, that talked about the apprenticeship world and wastewater treatment plants that will allow laborers to send out labor apprentices to do piping work. And the court held that DIR had recognized laborers to doing that work, and hence they didn't have to request for pipe fitter apprentices. And of course that caused a big seismic jolt into the industry. But that's some of the things. The court relied on what DIR had historically said when work was doing great before the Great Recession. We didn't have everyone seemed to have a lot of work, and as a result of that, some additional encroachment occurred during that time period, which became now historic, which now allowed really the use of pipe fitters now in a wastewater treatment plant. It's really hard to compete if you're signatory, because if I have a signatory laborers agreement, they can do the work as well, and they have a lower rate. So that's the challenges of public works law that we're constantly dealing with. So anything else? Ooh, I have 15 minutes, really, or more? I have. Oh my goodness, it says 15. Sorry, I'm just teasing. Operator. Yeah, so anyways, you kind of get an idea, though. Everything that you need is here on our website. You got my email address. Again, it's Sherry at, I'm sorry. Yeah, you just knock yourself out. I love it. It's all good. So, yeah, no, let me know, especially where we're letting, the public down in certain areas. If you're not getting your questions answered on our various email sites, I want to know. And we'll try to deal with that as well. And thank you for your time. I know this is a big commitment out of your day, so thank you.
Thank you, Eric. Please join me in thanking Eric, and actually Ken, even though he's gone already, but thank you for coming down and presenting that information. Be sure to fill out your evaluations, get them back to me, please. And if there's any leftovers, feel free to help yourself. Thanks again.